Hi, everybody. I'm going to try to work through some of these recent developments. I know many of you have seen an uptick, if not an outright slew of these complaints coming in recently, and are struggling to figure out what they are, why they're coming now, and how to deal with them, how to respond, and what the potential consequences could be. We're going to talk about what we can figure out reading the tea leaves on all of these issues. I'm going to try to move kind of quickly because it is, I understand, in the afternoon now on Friday, and it is still technically summertime, and everybody's very busy. This topic also involves Title IV, which of all the titles is I find to be the most boring. So in the hopes of keeping you all awake or catching you before you fall asleep, getting to the end of this, we'll keep moving quickly. So, real quick introduction here. Next slide, please. Uh, Generally, background of the student loan landscape. When people talk about a crisis in student loans in the United States, this is what they're talking about, and it's hard to disagree when you see some of the figures. Outstanding student loans in the United States are at an extraordinarily high level, both in terms of the number of individuals the number of borrowers that have those loans and the amount that they are. They're certainly all over the place. They can be, low single thousands or hundreds of thousands for individuals, and you're probably likely to see that reflected in some of the claims that you're receiving on the borrower defense side of things. In response to this crisis, the Biden administration has been extremely objective from the policy making perspective in trying to find ways to provide relief to individuals, and let's call them what they are, voters. They're going to be voters next year, so I expect that these kinds of programs, these attempts to provide relief, are only going to get more aggressive. And frankly, in this context, it makes me a little bit nervous, particularly when you pair this against what are really historic lows in the confidence that the public has in higher education. We're a sort of an easy target right now, we being the higher education community, for certainly for policymakers, for politicians. Oddly, one of the few areas where politicians seem to agree on student loan relief is borrower defense. You've seen statements from congressional Republicans that say, well, the borrower defense stuff is good. We don't like any of the rest of it, essentially. So again, it's another reason to be a little bit nervous and certainly very careful in this area. Next slide, please. So what is borrower defense? It's essentially a federal regulatory scheme by which students can seek forgiveness for their student loans, really of any size, again, under Title IV, by claiming that they have been tricked, misled, deceived in some significant way into taking out those loans, that they didn't get what they paid for, they didn't get what they borrowed for, and they shouldn't have to pay for it back. It is sort of the opposite of buyer beware, and I would say it's akin to a lemon law for higher education, saying I paid for this thing and it doesn't work. It doesn't do what it said it was going to do, and now I don't have the job that I thought I would have, and I have all these loans that I thought that I'd be able to pay, and now I can't. So it's been around for a while, but as with everything, it's sort of as with everything student loans, I should say, the Department of Education has gotten more aggressive in how it is utilizing this particular tool. That has led to some rulemaking changes and also some litigation. Next slide, please. The first piece of litigation that I want to mention here that I think has a significant impact on what we're seeing now is the Sweet v. Cardona case. And that was really a case brought by a lot of borrowers, sort of a class action against the Department of Education, not against individual institutions, claiming that essentially the Department of Education was not not responding appropriately under the law that was in place to borrower defense applications. Ultimately, that case is now settled. It was denied cert at the Supreme Court level. So we have a settlement in place that provided automatic relief to a large group of students. The total number of borrowers affected by this that at the time of the filing, or I'm sorry, in June 2022, so a year ago, was 300,000 borrowers. About 200,000 of those got immediate relief, which leaves, of course, 100,000 out there. And that's a bigger number than I think many, number surprising, at least to me, and I think to many watchers in this area as to how many of those outstanding borrower defense relief applications were out there just sort of hanging around. And I think it's surprising because we don't see a lot of them generally. It's not that commonplace to receive these, at least not in the way that we've been receiving them lately and sort of in bulk, as it were. So some of those were automatic. Others were settled under under the terms of the settlement. The Department of Education agreed for a process for getting through those applications. Next slide, please. And here's the schedule by which the Department of Education agreed that it would get through these applications. And you'll see it's fairly aggressive, at least at the early end. So why are we seeing a lot of these borrower defense claims now? Well, I think a lot of the answer is because the Department of Education, as we talked about some of the political forces at work earlier, and B, we have these legal forces at work in terms of this settlement agreement where they have agreed, the Department of Education has agreed to process these claims on a fairly aggressive timeline. And while many of the claims that we've seen recently over the past couple of weeks that institutions have been receiving fall all within this range here, and sometimes even beyond it, there is another group of borrowers that applied from June 22nd, 2022 to November 22. That's sort of a third category that's sort of wrapped up in this litigation. And then, of course, those that applied after that will be part of another discussion that we're going to have here. So you have sort of timelines all over the place. Unfortunately, we also have standards that are all over the place. And the settlement only provides limited clarity as to what those standards are going to be. And again, there are different standards depending on when the application was filed. Next slide, please. So add on top of that settlement, the rulemaking process that began in 2022 went into effect on July 1st, 2023. To really, the goal here, I think, is really to make it easier to apply for borrower defense relief, easier to win borrower defense relief, and therefore, from an institutional perspective, harder to defend. And I think that's really where we are now. Claims can be brought by groups or individuals. It's sort of an easier process, at least from the standpoint of the individual who's applying for relief, and that again goes along with the sort of approach that the administration is taking to student loan relief in many different ways. And institutions are sort of caught up in this thing now, trying to figure out where we fit and how we're supposed to reply and what role we are supposed to play. Some are very unhappy about it mainly for this last reason, that it allows for recoupment. So the loan is quote unquote forgiven and in some cases repaid by the Department of Education, but then the Department of Education, which does have limited funding, has to go find that money somewhere. And where's it going to look? It's often going to look back to the institution. Next slide, please. And so that led to some of these institutions that are probably particularly concerned, and that is the for-profit sector, which I think a lot of people would agree these borrower defense to repayment regulations are really aimed at the for-profit sector, because that's generally seen as the class of institutions that most aggressively recruits, uses, is more likely to use what is defined under the regulations as misleading terminology in their marketing materials and things like that. And certainly in the past has been most likely to be found responsible for defrauding students. So you have a group of really the Career Colleges Schools and Schools Association is the largest association of for-profit institutions. Their sort of Texas chapter brought this litigation, again, alleging that the 2022, which went into effect in July 2023, regulatory reform basically by streamlining, make it easier for borrowers to win their claims, made it harder for institutions to defend the claims, and ultimately will result in massive financial liability back on those institutions as they struggle to repay the Department of Education for the portions of those loans which may have been forgiven, or the numbers of those loans may have been forgiven. Now, those regulations went into effect in July 2023. As of August 8th, 2023, they are no longer in because the Fifth Circuit, very conservative circuit, probably the most conservative circuit based in Texas, in the United States, the Court of Appeals granted a national and nationwide injunction against enforcement of the 2023 rules. That will be heard on November 6th at the Fifth Circuit. I don't expect there to be any action on the 6th other than the hearing, because the very same panel that put the injunction in place is the panel that's going to be hearing arguments on the 6th. It's very unlikely they're going to lift their injunction unless the Solicitor General for the United States can be extraordinarily convincing to them that they were wrong back when they issued this in August. Then now in November they should immediately reverse themselves. I think more likely we're going to see some effect of this litigation continue for probably at least another year, maybe longer. Next slide, please. So getting back to sort of what borrower defense is and how it applies, I think it's easy to say misrepresentation or that somebody was misled. But what it really comes down to are these 6 factors under the 2023 rules. Now, we have different rules in 2016 and 2019 that apply to different groups of borrowers depending on when they took their loans and when they applied. I'm going to talk about that in a minute. But first, we'll focus on the 2023 regulations because eventually, in spite of the Fifth Circuit litigation, some version of these is likely to go into effect. And even if it doesn't, or even while they're enjoined from enforcing it or using it, it is likely that the very same regulators who helped write these are going to be evaluating the claims as they come in. So I think it behooves us to look closely at these and sort of think about the standards by which they want to evaluate these claims, which is what they put in these regulations, which are fairly expansive. The substantial misrepresentation of fact, particularly, the standard for that is actually set forth in the regulation. I won't read it to you because it will definitely put you to sleep. If nothing else that I'm doing today will. But I encourage you to go look at it maybe before bed tonight and read it yourself. It is at 34 CFR 66871. Write me an email to you. But you can find that. Then there are some other claims in here that are very interesting because to some extent they things like breach of contract claim or a judgment or a prior secretarial action all rely on things that may have already occurred. So, for instance, if the Department of Education has found a violation of the program participation agreement under Title IV, then that may be sort of an automatic, well, your institution was found to violate the program participation agreement, and therefore your loans will be discharged. That's a new section of this. The breach of contract, that's going to depend, or a judgment, maybe it is judgment for breach of contract, is going to depend somewhat on state law claims that may have already occurred in New York. Particularly, we may be a little concerned about this because we've seen some action in that area that suggests that sort of the contractual basis for the expectation of students, or the expectation students have of their institutions, can be fairly broad. Next slide, please. All right. So I mentioned that the the Cardona settlement may affect this. Here are some other aspects of the, or some other sort of past interpretations of what entitles someone to a successful claim under borrower defense. Maybe these, this is sort of one of the reasons why this is so opaque, so difficult, such a black box to look in to figure out what standard is going to be applied, because depending on when the claim came in, it may have a different standard. Depending on the effect of the litigation, it may have a different standard. Depending on the timing of the regulatory reform, it may have a different standard. If the Sweetie Cardona settlement procedures apply, it may have a different standard. And in some cases, there may be a different standard applied to the loan forgiveness and the recoupment action. So it may be that the loan is forgiven, but then there's a different standard applied as the Department of Education is looking to the institution to determine whether they can recoup those funds. So it gets fairly tangled here fairly quickly when you start looking at the timelines. And these are broad timelines. These are, the difference between July 2017 and June 2016, it may be very different. Or again, there's another big sort of turnover in 2020, where you may be in a very different scenario or a very different set of standards applying. And it may be very difficult, frankly, given the litigation, given the injunction, given the regulatory reform, where you are in that at any given time. So next slide, please. I mentioned the Sweet v. Cardona settlement has some of its own standards. They're much less clear than the regulations, which in my mind, I guess if the current batch of applications are being resolved under the settlement, and you have an aggressive Department of Education that is resolving those, and they're doing it under fairly ambiguous set of standards. I worry. Let me say that I worry about how some of these things may turn out, about the application that about the standards that may be applied. Basically, here are the terms of the settlement. It's a streamlined review. It does not require additional outside evidence. So when somebody submits their application, that's basically what the department is going to look at. It does not require proof of reliance, which is just, I'm not even sure how to interpret that, because I thought the whole point is that you relied as a borrower on misrepresentations by your institution, but I guess that's not always the case. And there's no statute of limitations. Now, thankfully, there is still statute of limitations in place as to how far back recoupment actions can go. We'll talk about that in a minute. But basically, this litigation not only set this sort of vague procedure in place, it set clear timelines, and it is silent as to whether or not something that is evaluated under these standards is going to be subject to a future recoupment action. So if a student under the borrower settlement process is able to get release of their student loans, whether or not the institute or the Department of Education come back to an institution for recoupment at that point, if they process it under the settlement, is an open question. I think most institutions would say no. The Department of Education, as it's looking to keep the lights on in its building, buildings, I should say, may say yes, and they may very well come after institutions, particularly where there's larger figures involved. Next slide, please. Which brings us to the general topic of recoupment here. Generally, there is a six-year statute of limitations on recoupment actions. Now, that is told while an application is processing. So if somebody filed an application in 2017 and the Department of Education hasn't done anything with it yet, presumably that could still be, even though more than 6 years has passed, the Department of Education could still go after the institution for recoupment because the statute of limitations was told while the borrower defense application was pending. There's broad authority here for the DOE to sort of apply the standards that it will in assessing liability to an institution. And then ultimately, these are going to be adjudicated under the same appeal procedures that apply to audit and program review determinations. It's a very standard sort of administrative hearing that's set forth in the regulations. And again, we're going to ask, does this apply to claims evaluated under the Sweet settlement? the problem with that is even if ultimately the legal a decision on that is no, somebody's probably gonna have to litigate it once the Department of Education starts bringing those recoupment claims, and that may be more, litigating at the federal government may be more expensive than just paying the claim or coming to some kind of settlement with the Department of Education. We certainly want to avoid that if we can. Next slide, please. So, institutional responses, that's sort of the $1 million question right now is, you've got these things. I'm assuming many of the people on this presentation today are here because you received some of these probably fairly recently. One, or we've seen some even smaller institutions receive many of these all at once, and you're trying to figure out what to do with them. So the DOE has notified you and has requested a response. I think that request part of this is a little bit misleading, because I really think you have to respond, and I'll tell you why in a little bit. But such notification is also going to include the notification that the tolling period is in place that we talked about earlier. It says under the regulations that you have 90 days, but I know most of you that have received these recently were given 60 days. I don't know what is to account for the discrepancy. It may tie back to the settlement under the Cardona litigation and the streamlined process, and the fact that they need to get these things evaluated in a certain amount of time. But the regulations say 90 days, even though your statements or requests for information say 60 days. So you also have to include in any response an affidavit under penalty of perjury. I think that was probably attached to what many institutions received. If not, it's certainly easy to find. Next slide, please. So, should you bother responding? I already answered it for you. Yes, you should. It's important to respond. And next slide, please. Motion light there. Why should you respond? Because, frankly, the department evaluates these claims pursuant to the information that they have, and you leave a vacuum of information if you don't provide any on your end. The consequences of that, of an adverse finding, can be very severe. You could be ultimately required to face a recoupment action for tens or even hundreds of thousands of dollars, maybe even more than that if you have multiple claims. If you have, if you're subject to a group filing, or if you have many larger institution, particularly with many, hundreds of thousands of dollar claims, that can add up extraordinarily quickly to a very large amount of money. And sort of oddly, the larger you owe, the more likely you are to face the larger number the DOE sees, the more likely you are to face a recoupment action. So certainly we all want to be prepared for those if they ever come. The evaluation process, as we've discussed, and the criteria that the department is applying are very opaque. It's very difficult to figure out exactly how they're going to evaluate these things. So we want to make sure we are responding aggressively and putting all the correct information from our point of view in front of them when they are making that decision. As we've talked about a little bit already, that their sort of motivations for deciding these things, I think, are sort of stacked against the institution in a lot of ways. And wrong or right, that's just the landscape that we're facing at this point. And if ultimately, if the institution does not respond, and this is right in the regulations, the Department of Education will presume that the institution does not contest the claim. If there's any good reason, if I have given you no other good reason to make sure that you respond to these things, and at least say, no, we deny it, then this should be a good enough one. That if you don't, you're presumed to sort of agree with whatever the borrower has submitted. Next slide, please. So practically, how are we responding to these things? Well, frankly, it's still a work in progress. We're working on it. We have a bunch of these that we are working on with various clients and institutions, many of you who are on this call, I'm sure. But here's sort of the outline that we're working with. And I want to give credit to my colleagues, Gail Norris and Sandra Casey, for helping work with some of these, or help work through how we're going to respond to some of these. There's going to be a factual refutation claim because, again, we want to make sure that we get our facts and documentation to the extent it exists in front of the department as they're making their decisions. And then we're going to make some legal arguments. Certainly, we're going to make defenses that arise out of the face of the claim itself. There may be things that the borrower has said or boxes that they've checked in some cases right there in the application that give us an opportunity to say, see, there was no financial harm here, so what are we even here for? Or there was no reliance, and that reliance question again, I even though the sweet settlement says that reliance isn't necessary, I still think it's an important factor to focus on, because I think that really ties back to what the whole intent of these regulations is meant to be. We're going to address the damages. I want to give some credit to my colleague Jeremy Colby here up at Niagara University for bringing up the fact that uh, even though a student may take $100,000 in loans, part of that is immediately given back to them for living expenses. So it's not the institution's responsibility to have wisely spent those particular funds. So automatically, we should be pointing that out to the Department of Education. And then we're going to break down factor by factor based upon the standards we discussed earlier, based upon the definition of misrepresentation in the regulations, whether or not those regulations may strictly apply. I think we have to assume that the Department of Education is going to be at least considering that as the definition they're looking at. And then ultimately, we're going to make sure that we put in our sort of placeholder arguments about things like statute of limitations and lack of due process, regulatory concerns that we may have, not because the Department of Education is necessarily going to agree with those, but if we ever do end up in litigation or an appeal process, or even the statutory, or sorry, I should say regulatory administrative process, that we preserve those arguments, and that we don't make it easy for a judge or an ALJ someday to throw them out because we didn't ever raise them, we didn't bother raising them in this initial response. So we want to make sure we put those in place. I would also say we'll probably suggest that if there is any reply to our response from the borrower, that we get an opportunity to see that and respond to it ourselves. So sort of, we like a rebuttal argument, I think, is something that we'll be putting in there. Next slide, please. So what should we be doing now? I think designating a point person, because you may only have 3 of these now, but you've seen how many are out there. You've seen the fact that the department is trying to make it easier for people to file these. They actually are making it easier for people to file these. It is likely that those 3 will turn into more. And so I would start getting my arms around those now, having somebody in charge of dealing with them if you don't already. Somebody, this is part of their job description now, unfortunately. Is to deal with these things, to start collecting documents, wherever those may be, based upon the nature of the allegations in the claim, to track the claims, track the response times. Again, we have a bunch of different response times, a bunch of different claims coming. You probably, if you've got sort of one wave of claims, you may get another one in a few months, and you want to make sure we're separating those, keeping tabs on when our responses are due. Do you need a lawyer to respond to these? And that maybe not necessarily. I certainly encourage you to have one. Some of the legal defenses and arguments that we want to be raising are best probably made by counsel. I think getting this right early is important, and having counsel that has experience in this area is going to be important. And ultimately, having counsel in early on in the process is going to help you if this goes to another step in the process later on. So it's going to sort of help you respond to that efficiently and hopefully effectively. Whether that be a recoupment action or some kind of challenge to the regulatory standards that are put in place, or some kind of challenge under the settlement. We'll see where it goes, but I think having counsel involved now is going to help you. And again, the consequences are potentially so large that it's just worth it to make sure that we get it right. So then we're going to draft and submit responses, and we're going to watch, and we're going to wait. As you saw by those timelines, they go all the way out to 2026. And that includes some of the applications that we've received already from 2000, early 2022, those timeframes. So they are asking for our response in 60 days, but they have almost 2 years to actually figure the thing out themselves at the department level. So I think watching, waiting, again, there's litigation going on here. There's rulemaking going on here. We want to be watching these things and see what's happening. There may be future guidance coming out from the department. We want to make sure we're keeping a close eye on everything that's going on in the background here, and all the machinations at the judicial and regulatory level to make sure that we are responding appropriately and doing the best we can to stay out ahead of these things. And with that, I'll let you all go back to your Friday. I don't see any questions in the Q&A, but I'm sure that many of you have them. So feel free to reach out to either me or whoever your primary contact at Bond is, and we'll make sure we get you caught up. Thank you, everybody.